But I come from a community where we have so it's not like there. What?
It should be there.
Yes.
Yes. We do have a problem of island. Then we have Uguru. They are present. Yes. Yes. And then they will have.
So you are for which is for all?
We are a team.
We are a team for all.
Yeah, for all. It is easier that way.
And of course,
Yes. Eh? Oh, sorry. I'm so sorry. I'll take him for a cup of coffee so that it can mitigate.
Yes.
The movie is coming up for hearing.
It's in Gambia. It's already, yeah.
The matter is coming up for hearing. However, now part you're not ready to proceed for the following reason. At the time when the accused were arrested, there is a vehicle which was impounded, and it's alleged the items were recovered from.
I think you see.
The time when the vehicle was impounded, it's alleged that there are certain items which were found in the said vehicle, and the said vehicle is also an exhibit in this case. However, we are not ready to proceed because on the face of the vehicle, the registration number was appearing as KCJ 411X. KCJ 411X.
Yes.
X. Yeah. However, Your Honor, upon the IO writing to the NTSA to get the details or the particulars of the owner, as from the chassis and the particulars appearing at NTSA, the registration number is 63 UN 307K.
What is that?
It's the number plate, the number of that vehicle, as per the chassis.
The chassis
is 63 UN.
63 UN.
Then 37K. Yes, Your Honor. And the IO wrote wrote a letter to the said NTSA wanting to get to know the particulars or the ownership of the said vehicle. But as of today, Your Honor, they say the details have not been furnished to us to be able to know who is the rightful owner of the said vehicle or whether there was any changes in terms of ownership. And being part of XB that we intend to rely, Your Honor, we are requesting for an adjournment today as we try to get the details of the safe ownership of the safe vehicle first before we can proceed. That's all, Your Honor.
Yona Ndegwa. As usual, Yona, there has been serious efforts from the state to
create some sensational effects about this case. And that is why, Your Honor, you're being told the reason why you cannot proceed today is because there is a vehicle that is allegedly registered as a UN vehicle. That is 63 UN. You know, counsel was not informed whether he has the witnesses for you. I indicated, Your Honor, and this will be traced by my learned friends. There is serious attempts by the state to create sensational effects or feelings to members of the public about this case. You know, you've not been told whether, other than this, there were witnesses before you. When they abducted the accused persons, and I'm using the word abducted deliberately,
Slow down for a second.
I'm obliged.
You're not told much. Witness.
Yes. You know, when they abducted, and I'm using the word abducted deliberately, the accused persons, and when they had the accused persons arraigned before you, subsequent to which this date was taken, the prosecution is presumed to have been aware of its facts, or is deemed to have been aware. And with the utmost respect, my learned friends whom I schooled with, Mr. Cosmas, that is not a sufficient ground because for adjournment, because they are the ones who dragged us to court. It's unfortunate that the state, despite the heavy taxation of Kenyans, they are not able to prepare their case and get it ready for hearing. You know, we consider this an application for adjournment as an assault to Article 50 of the Constitution, and a delay that is not explained. They have done the searches as been indicated from the letter that counsel was referred to. And unless they have any other NTSA within or without the Republic, I don't see whether they receive any other results. We want to insist that we are ready to proceed with this case. And that the application for adjournment be declined, so we can safeguard the rights to a fair trial that the accused persons are entitled to. You know, my colleagues will trace on that.
Your Lordship, just the two issues. This is a court of law, guided by the rule of law and due process and the Constitution. And I wish to refer you to the preamble of the Constitution, Article 10, Clause 2E, Article 50, Clause 2E, Clause 2E, that the integrity of the process must be protected. And I will highlight that before I mention you the other articles. Once you arrest and you bring to court, the presumption is that you have laid a prima facie case against the accused persons. It means that you can take off. So you cannot arrest, take to court, then you seek for more time to beef up your investigation. Then you will be interfering with the doctrine of separation of powers, which gives autonomy to the investigators to do their work after they are convinced that this is a case which has met the threshold to take to court. They bring to the prosecutor who files it. Then the third process is guided by the court. But if they are not ready, they can keep it as long as they can to maintain their autonomy. But once they have brought it to court, then they are subject to other principles of fair trial and fair hearing. So, Your Lordship, the integrity of the process under Article 10, Clause 2E should be protected so that the court should not allow further investigation to continue as we proceed, because that will be highly prejudicial to the accused persons. Secondly, Your Lordship, in Article 50, Clause 2E, it states expressly that once the hearing commences, then there should be no unreasonable delay. Your Honor, the explanation given by my learned colleague is about a motor vehicle. This case is not just about that motor vehicle. This case has a life, an identity of itself, but it's not just about that motor vehicle. So, at least they should be able to take off because they have other witnesses other than the motor vehicle. The reasons given, Your Lordship, are not plausible. Because you see now, we had cases in Mombasa, in Nakuru, but we never went. We committed to come here and proceed. So that's not then I take you to Article 159, 2E, which obligates this court to apply the constitutional principles, protect them, and enforce them. Your Lordship, I wish to submit that these constitutional principles are not just paper aspirations or declarations. It is the duty of the court to enforce them. So, if learned counsel, but I have to be honest that the learned counsel should have even told us in advance that I have a challenge, because he's a good man. It's only that he's coming to ambush us today during the hearing. He should have told us. He should have had a courtesy to tell us, I have this challenge and I think you need to be prepared. So I propose that as a way forward, we can proceed with whatever witness he has, because I think he has two. He has two witnesses. So let him proceed with the two he has. The rest we can proceed later.
Your Honor, I'm John Maina.
You,
John Maina.
what's my number?
It's the same. John Maina and Njenga. Your Honor, our clients under Article 48 have a constitutional right to access justice. And Your Honor, the impediments placed along the way by the prosecution should be ignored. So, Your Honor, we are ready to proceed, and the arguments they are bringing forth should be expunged from the record.
Your Honor, with your permission, just think I'll raise only Guru Simon, yes, just for one point. But I associate myself with the submissions of my colleagues.
and only wish to point out to the court that it is now settled that discovery of evidence is a continuous process. It is a right that is open to the prosecution during trial, as long as that evidence is sufficiently supplied to the defense and they are given an opportunity to interrogate and do justice to it by defending the accused persons. Therefore, it is and cannot be used as a reason for seeking an adjournment this morning, that they are waiting for a certain letter from the NTSA. That cannot be a reason sufficient enough to take out this matter from today's hearing. That is all.
Your Honor, good morning. Yes, my name is Gatia. Yes, I only have 2 points to raise. One of them being that expedited trial. An expedited trial is one of the foundations or the cornerstones of our criminal justice system. These submissions that this is my submission, however, counsel and the prosecution have had sufficient time to prepare. Yes, Your Honor, what I'm saying is the prosecution have had their time to prepare for trial. It is imperative to speak. More investigations are going on because of the issue of the motor vehicle. And I believe, as my senior said, the issue of the motor vehicle does not form the crust of the investigation and the charges which have been proffered against our witnesses. And for that, I believe the reasons that the prosecution have raised are insufficient. It is a humble prayer that we should proceed with today's hearing. I so submit.
I think Njenga. The defense has alleged that the prosecution intends to delay the matter, but I wish to submit that the plea was taken in July this year, and immediately after the plea, the IO took the initiative to write to NTSA on the 19th of September so that we could get the details of the ownership of the
Your
same.
Lordship, I thought in reply it's only points of law. He's bringing in new facts which we cannot be able to respond to. Strictly on points of law.
I just want to clarify on the issue of whether we have delayed the matter, because as I put it across, the IO has taken the initiative to find out the ownership of this vehicle. It's only that it came to our knowledge immediately after NTSA furnished us with the details of the ownership of the said vehicle, that it had another registration number, which was not even to the knowledge of the IO. The knowledge of the IO as the time when the accused persons were being arrested. Your Honor, further, it's been alleged that investigations ought to have been completed at the time when the accused persons were being arrested. Your Honor, our office had exercised the public interest test, which
Mr. Mbogo has helped you.
Yes, that's what I wanted to show the contradiction. Why is saying that
No.
the investigations ought to have been complete? He's saying disclosure is a
No, that's
continuous
admitted
process.
by the defense.
But he was saying that actually investigations
It's
ought to have
admitted.
been
Your Honor, I
completed.
think my submission was sorry on the point that I
Yes,
currently
I
admit
totally
that
understood what
Yes,
you're saying.
yes.
you said that this is not an excuse. You can continue doing it. So
Yes.
long as you discuss to us
Yes.
in good time.
In good time.
Exactly.
And,
Yeah.
so I understand. Did I understand?
You did.
Yeah, I did.
Yes.
Yes, I did.
Thank you very much.
And that's the reason why Your Honor, we are submitting that it is a key exhibit to our case because it's alleged that these items were found inside the vehicle. The court ought to know where exactly these items were found and who's the owner of the said vehicle. That's why we need to get the details first before we can proceed. Further, defense had alleged we had not bonded. Actually, we had bonded 2 witnesses, thinking by today we would have gotten those details. But unfortunately, as of today morning, they are informed me that the said details have not been furnished to him. Your Honor, it's the first time the matter is coming up for hearing, and we have no intentions to delay this matter. Once our house is in order, we'll be ready to proceed with the said hearing.
You know, I don't know whether I should also make another application that once you render yourself, you will just do one composite one. But let's first of all get directions on that one, perhaps.
We have no audience now. After
No,
you
but it's an
spoken,
application I wanted to make.
That's why my pen paused.
yes. Yes. And your lordship, we don't want to put pressure. You can go relax and make your own.
I want to judge whether I can actually make it
Yes.
no, that's what I'm doing. But
Okay.
so can I give you a ruling in 10 minutes?
Yeah, we can have a short break.